Well, hi, everyone, and welcome to today's program, FOIA Fundamentals with the First Amendment Clinic. I'm Dina Meredith, VPA's Communications Manager. As you already know, the VPA partnered with the University of Virginia First Amendment Clinic this summer to establish the VPA FOIA Hotline. It's a free service to all VPA member publications to provide guidance on FOIA, First Amendment, and open meeting questions. The hotline, which is open 9 to 5, Monday through Friday, and is monitored after hours, is overseen by Ian Kalish, one of our presenters today. Ian is a legal fellow at the Reporters Committee for Freedom of the Press and a lecturer at the University of Virginia School of Law, where he teaches in the First Amendment Clinic. His practice includes matters of defamation, government employee speech, right to protest, and access to public records, and he frequently litigates in state and federal court. Through his work with the UVA Clinic, Kalish has successfully compelled the release of state and federal public records on behalf of journalists. He also oversees VPA's FOIA Hotline, assisting journalists across Virginia navigate issues surrounding public records and open meetings law. Also joining us is Chinmayi Manjunath. She is a third-year student at the University of Virginia School of Law and a member of the First Amendment Clinic. During her first summer as a law student, she interned for Justice Leondra Kruger at the Supreme Court of California and spent her second summer in the litigation department of Baker Botts in San Francisco. She has a degree in mathematics from Williams College and a Fulbright scholarship to Bulgaria. Thanks to both of you for being with us today, and I'm going to turn everything over to you now.
Thank you so much, Dina. As Dina said, I'm Ian Kalish. It's very nice to be here today and to be talking with you. I just wanted to provide a quick overview of what we'll be discussing and then kick things over to Chinmayi to sort of give a little presentation. As you heard, the UVA Clinic is administering the Virginia FOIA Hotline. And so, one of our goals behind this session was to kind of be a little bit introductory, kind of share a bit about who we are at the clinic, what we do, discuss the hotline, the kinds of questions we cover. And then we're also going to provide just a pretty brief overview of the Virginia FOIA statute, including, certain hot topics or issues that journalists might encounter throughout their work. And then after that, we're going to leave ample time to field questions. We're curious if you have questions about the statute generally, or, because we're pretty new, we're kind of getting the hotline kicked off. We're curious to hear about, past issues that, might have been concerning, just so we kind of get a sense for, how things have been playing out across the state. So like I said, we'll leave a good chunk of time at the end of the session, and then Chinmayi will be running through sort of a more formal presentation. If you have questions, you can feel free to drop them into the Q&A tab through Zoom, and we'll try and field them as they arise, and then or we can circle up at the end and go over everything. So with that, I think I'll kick it over to Chinmayi.
Hello, everyone. My name is Chinmayi Manjunath, and I'm a third-year law student at UVA and a member of the First Amendment Clinic. Just to expound on Ian's introduction, today's presentation is meant to give you an overview of the work that we're doing at the clinic and the hotline that we're running in conjunction with the Virginia Press Association. And the presentation is going to cover the basics of accessing public records, closed sessions of public bodies, closed judicial proceedings, and judicial records. And we're going to leave time at the end to field your questions, and Ian is going to handle most of that. Oh, is it working? All right, to begin, this is a year-long clinic at the University of Virginia that is supervised by our CFP lawyers, including Ian. We work in teams to conduct legal research, meet with clients, and draft legal filings. Our assignments cover appellate and trial level litigation in state and federal court, including the Supreme Court. We represent journalists like all of you in First Amendment cases that include defamation matters and public information access rights. We also advise and train local journalists on VFOIA and open meetings law, and that's what we're doing today. So that you get a better sense of our projects, here are a few recent examples of the sort of work that we do. The first is a Federal Freedom of Information Act case involving UVA law librarian John Ashley, who now works at Darden. And he maintains a publicly available database that compiles non and deferred prosecution agreements made between the Department of Justice and various corporate defendants. These are agreements not to prosecute in return for payment of fines and reformation of behavior according to government specifications. And some examples of these agreements that he's unearthed include a settlement of a sex abuse scandal by the Roman Catholic Archdiocese of Boston and a fine paid by Las Vegas Sands for failure to alert authorities that an international drug trafficker had made suspicious deposits at their casino. A previous iteration of the clinic began work for John Ashley in 2013, and their work and ours has involved some combination of FOIA requests and lawsuits. This case has been a bit of a slog to give you some idea of how long the government can sometimes take to release records. But however, a few weeks ago, we received a lot of great information from the civil and criminal divisions at the Department of Justice. A second case that you might have seen on the news involves our work for Forbes Media. There we help journalists unseal court records related to the government's use of a 250-year-old law called the All Writs Act to compel private travel agencies to release information about their clients, and in particular, a Russian hacker named Alexei Burkov. And because Moscow doesn't have an extradition agreement with Washington, our government had to wait until Burkov was out of the country to arrest him using data gathered from these travel agencies. And so he was arrested in 2015 after a holiday in Tel Aviv, and he pled guilty to various charges in 2020. The All Writs Act allows the government to ask for non-burdensome assistance from entities not directly related to a given investigation. And the law, you might have seen it on the news, it gained some notoriety in 2015 when the FBI tried and ultimately failed to use it to force Apple to open an iPhone belonging to a suspect in the San Bernardino mass shooting. And the problem with orders under this act is that they don't get the same legal or public scrutiny as search warrants and wiretaps. They're routinely filed under seal and allow the police to capitalize on private data collection. And so our clinic worked with Forbes to get some of those records unsealed. In addition, we run a hotline with the VPA, and this hotline is meant to provide information about Virginia's State FOIA Act. The contact information is on the PowerPoint, and it's also, you can find it online. And we actively monitor your calls and emails during normal business hours, and we also keep an eye on the hotline at other times. So when to call the hotline, you should call the hotline for questions about public records law and open meetings law, as well as access to court proceedings and court records. Making a records request, stopping or gaining access to closed proceedings, and dealing with delays and redactions in the release of records are all topics that we can help with. That said, the hotline is for informational purposes only, and responses to hotline questions do not constitute legal advice. You may encounter legal issues that require the representation of a lawyer in your capacity as a journalist, including representation in Virginia FOIA actions, as well as subpoena or defamation defense. And if you need legal representation, please do let us know, and we'll schedule a time to discuss the possibility of entering into a formal agreement. And if the clinic is unable to exist, we will also do our best to find alternative counsel for you. We also can't help you with questions clearly outside the scope of our expertise. So for example, any questions you might have about internal employment issues, including contracts, employment disputes, and unionization, those are all things that we can't help you out with. So in the news, the service that we're providing through the hotline is one that can end up being very helpful for you in the course of your duties. Public records and open meetings have played a major role in recent news federally, but also within Virginia, and we can help you navigate that process. So to provide a few examples, first, a Virginia occupational health and safety officer is currently investigating a chemistry classroom fire that burned 4 students, and we know this according to a public records request, and this was reported by CBS 6. Another example, to learn about the state of school emergency relief fund plans from the pandemic, so how that money is being spent and how much is left, because the deadline for spending that money is fast approaching. Over the summer, the Richmond Times-Dispatch sent public records requests to each of the state's 132 public school systems. A third example, public records obtained by VPM show that the Department of Elections received more than a dozen support tickets from local registrars in late May regarding a problem with data that they get from the DMV. And again, from VPM, FOIA requests were also made to every single Virginia public school district, asking for records of resignations during the month of June for the past decade, in order to better understand the teacher shortage that Virginia faces. And this actually ended up being too expensive, so the years that define the scope of that request were cut in half, and we'll have more to say about cost to you later in the presentation. And also as an example of open meetings law in the news, because there's not as much, council members in Parksley are suing the mayor and others for illegally going into executive or closed sessions and using these sessions to discuss non-exempt topics, and I'll explain later what that means, and silencing open meeting discussion regarding town business that should be shared with the public. And finally, on behalf of VPN, attorneys for the Reporters Committee of the Freedom of the Press sued Virginia's Department of Education in April for refusing to disclose a record related to the governor's executive order banning critical race theory in the Commonwealth's K through 12 public schools. And this case was actually resolved without suit, and it involved one of our other clinic professors, Lynn Weeks, who's not with us today. Great. So this next part of the presentation covers the basics of the relevant laws, public records, open meetings, and court access and records. So first, I'm going to walk you through an overview of public records requests. Those are requests made to public bodies, defined as those supported wholly or principally by public funds. What that means is kind of complicated, and many exemptions also apply, and we'll go into more detail in a later slide, but to provide a few examples. NGOs, corporations, or agencies that receive public money are not principally supported by public funds are not public bodies, but ones that are principally supported and perform public functions can be. Moreover, like the presence of a government official on a governing body of an organization does not necessarily mean that that entity is a public body. The Office of the Governor, the Virginia State Police, the School Board, the Virginia General Assembly, and George Mason University, those are all public bodies. But the George Mason College Foundation, a nonprofit established to raise funds and manage donations to George Mason, is not a public body, and neither is our legislative caucus. And again, this is like a highly fact-specific question, and one that the hotline is going to be able to help you with. Because public records requests can be a slow and frustrating process, you should ask first if someone else has already received the records, or if there's some other way to get that information that you need. If not, then it is time to make a request. Any Virginia citizen or members of media organization with circulation in Virginia have a right of access to public records under the Virginia Freedom of Information Act. Regrettably, the act does not make any mention of online media, and states are allowed to discriminate against out-of-state requests. That said, nothing in the act prohibits a citizen from making a request on behalf of a non-citizen, as a valid requester is not required to justify or explain the request. And in fact, you probably shouldn't explain your request. So what can you ask for? You should note first that the public bodies are only required to provide records that already exist. They don't have to create a new record for you, although they may summarize some information under like terms and conditions defined between the two of you. Second, these records may comprise all documentary information that are written or recorded, and these would include papers, reports, letters, DVDs, emails, films, photographs, and sound recordings. And these records can be physical or electronic copies, but physical objects that can't be reproduced, so like a museum exhibit, those don't count. You can't request them. How do you ask for this information? So the format of your request should be pretty specific. So for instance, if you're asking for emails, you should also ask yourself if you want, attachments, BCC addresses, or the personal addresses of government employees that are used in government business. You should also specify the preferred format of the records. So for instance, if you want the results of a database search recorded in an Excel sheet or a PDF. And finally, you should consider using limiting factors such as keywords, dates, and locations. So if you're on a fishing expedition, you would want to use phrasing such as all records that contain or reference, and then your search terms. So like fiscal year 2019 budget, and not phrasing such as all documents pertaining to or related to X. And you should keep in mind that the more you ask for, the more time the government is going to take to get you what you need, and the more expensive that search is going to be for you. Once you've formulated your request, you should submit it to the FOIA officer that is listed on the public agency website. And if that information is not available, then you should email the agency to request their contact information. The Virginia FOIA Advisory Council also maintains a list of designated FOIA officers, so you can check that list out. So who can you not request records from? There are many categories of documents which are excluded from coverage under the Act on other grounds, such as an applicable exemption, but these are the only public bodies as defined by the Act, which are wholesale excluded from coverage by the Act. And these are the Virginia Parole Board, juries, the Virginia State Crime Commission, family assessment and planning teams, sexual assault response teams, and multidisciplinary child sex abuse response teams. However, pursuant to a new amendment enacted in this year, the individual votes of the parole board are now subject to VFOIA requests. So what happens next after you've made your request? For Virginia FOIA requests, the government has 5 working days to respond, not with the requested records, but just to say that they're looking into it. And in their response, they can either provide or withhold the entire record, provide part of the record, or let you know that they're going to need another 7 working days to fulfill your request. And following a 2016 amendment to VFOIA, the government has something called a duty to redact. This means that when part of the record is exempt from disclosure, but the rest of it is not exempt from disclosure, the government has to give you the non-exempt portions of the record. And if part of the record is withheld, the government must provide a citation to the portion of the statute that justifies this action. And if a public body can't find the record that you asked for, but it knows that some other public body has it, then it has to provide you with that body's contact information so that you can continue your search elsewhere. Finally, a failure to respond to a request within those 5 working days constitutes a denial and would violate the statute. But that said, the public body may petition for additional time to respond to requests for an extraordinary volume of records or requests that involve extraordinarily lengthy searches. Unfortunately, the statutory deadlines for public records requests are rarely followed in Virginia, and redactions are pretty common. So if you are dealing with a response delay, you should respectfully and courteously follow up with the FOIA officer to ask for an estimated date of completion or guidance on limiting the scope of your request. Doing this can nudge an agency into compliance because it shows them that you're taking the process seriously, so they should too. And when you do finally get a determination, you have the option of petitioning the court directly if you're not happy with the results. And this is your only option. There are no administrative appeals. And while Virginia FOIA Advisory Council will clarify the requirements of the law and guide future practices, it does not mediate your disagreement with the public body. This is a chart that's produced by Muckrock, which is a nonprofit that assists journalists in requesting and accessing public records. It also maintains a database of requests submitted through its service and tracks statistics from the public bodies with regards to outcomes, timeliness, and so on. And as you can see from the pie chart, public bodies are often going to keep you waiting. Comprehensive data for Virginia FOIA requests are not widely available, but this should give you an idea of what to expect. So as you can see, the allowed response time is 5 days, but the average response time is 35, and a minority of request determinations had been completed at the time of the creation of this chart. All right, so the first hot topic, I submitted a request to the agency, but they're charging me $500 for the records. What can I do? Public bodies are not, or they are permitted to make reasonable charges, not to exceed the actual cost of accessing, duplicating, supplying, or searching for the records. What this means is somewhat unclear, but we know that it also includes one exclusion review, which is where the government identifies the portions of the records to be redacted before they give it to you, as well as the cost of estimating costs. And an estimation of costs must be shared in advance if you request it, and you should request it. And when an estimate is provided, you will have to reassert your public records request in order to start the clock. And if that estimate is greater than 200, so 500, the public body may also require you to pay a deposit before it begins its search, and the time period allowed for a response will be told until you pay that deposit. In practice, small requests often don't carry a fee. So Muck reports that only 11.4% of requests have a fee, but the average fee imposed when it is imposed can be pretty high, approximately $6,000. So in these situations, you should ask for a fee waiver in the public interest, although you should know that there is no statutory fee waiver provision in Virginia. But you know what, it doesn't hurt to try. You could also try narrowing the scope of your request, and this is what VPM did when its request to Virginia public schools for records of teacher resignations in the month of June from the last decade proved to be too expensive. All right, so I've submitted a public records request to a prison, but they rejected my request, saying that they are records of prisoners related to their imprisonment. Can they withhold the records? The short answer to this question is yes. The FOIA treats the disclosure of prisoner records as discretionary. Other discretionary disclosures in the realm of law enforcement include criminal investigative files, personal information about participants in neighborhood watch programs, tactical plans, officer phone numbers, and the list goes on, undercover operations and protective details, the identities of victims, witnesses, undercover officers, investigative techniques or procedures, and information from the sex offender registry that is not mandated by law to be publicized anyway. Moreover, when criminal incident information is likely to jeopardize an ongoing case or the safety of an individual or lead to the destruction of evidence, law enforcement can also withhold that information until the risks dissipate. And finally, prohibited records, in other words, like records that law enforcement can't release even at its discretion, include the identity of any individual providing information about a crime or criminal activity under a promise of anonymity. Almost all the applicable exclusions have been codified in the Act, so you can take a look and read them for yourself, and they can be pretty lengthy and repetitive. I'm just going to give you like a few more examples as a taste of what's there in the Act. So other exclusions include those of personnel records, written legal advice, records related to negotiations or award of contracts prior to the awarding of that government contract, records related to public safety, such as confidential records from rape crisis centers, or subscriber data from a telecommunications carrier, confidential information related to administrative investigations, such as those related to license and permit application investigations or attorney general investigations, education records, such as confidential recommendation letters, identifiable individual information from the Brown v. Board Scholarship Awards Committee, proprietary information from UVA, health records, non-processed patient level data, proprietary records and trade secrets, such as those from government contract bids, and records of specific bodies, such as state income and business estate tax returns, confidential records of the Department of Corrections, and correspondence of the governor, the attorney general, the members of the General Assembly, and so on. And unless otherwise prohibited by law, most exemptions allow discretionary release, but this is very rarely exercised.
And just to chime in on this point real quickly, Chinmayi, I guess like everything, like how the way these exemptions work is like you're always starting from the position of openness, right? So that there's an assumption that the records you're requesting are freely accessible. So, there's the general presumption of openness, and then like Chinmayi said, the exemption, oftentimes it's discretionary exemptions, sort of remove that presumption of openness and like make it a discretionary call by the records custodian. But when you're assessing the specific exemptions, like they're all listed out in the statute and a lot of them are repetitive, but you just need to be very careful and about reading the exemptions, looking at the records that you're requesting, the position the agency has taken, and sort of determining if the agency is sort of correctly exercising its discretionary authority. But
so when can't they withhold records? There are a few examples on the PowerPoint, but this is, as Ian said, this is like a pretty fact-specific question, and there's, a lot of information in the act, and public bodies are also going to drag their heels. So it's important to be pretty persistent, and of course, call the hotline or us if you have any questions. Next, I'm going to walk you through an overview of open meetings law. To figure out when and where a meeting will be held, you should make a written request with your mailing address, your organization, phone number, and email at least annually for every governing body that interests you. Notices are also going to be posted on the body's official website in a prominent public location, and the office of the clerk or chief administrator of that body at least 3 working days prior to the meeting. And if an emergency or special meeting is planned, then the notice must be provided to you and the public at the same time that it's provided to members of that body. At open meetings, votes cannot be written or secret, and with some exceptions, minutes must be taken, and these minutes must be made available to the public within 7 working days of being finalized, and you should be able to find those minutes on the public body's website. And if no website exists, then copies should be posted in a prominent public location or the office of the clerk or chief administrator. Finally, the remote location of members must be recorded if they attend the meeting electronically. Electronic attendance is typically permitted only if a quorum is present physically or a state of emergency has been declared. Although the law has recently changed so that some bodies may conduct all virtual public meetings, and all virtual meetings should also provide links for attendance to the public and members of the press. Next, closed sessions. So when a public body wants to go into a closed session, certain procedures have to be followed. First, they have to start in an open public session. Second, they have to provide justification for going into closed session. And third, they must vote publicly to go into closed session. And then after the closed session, they have to come back in open session to take a roll call vote, certifying that only matters permitted by statute and identified in the motion to go into closed session were discussed. Closed sessions are permitted in 46 situations, and you can find them all in your VFOIA guide, but most commonly when the subject matter implicates privacy concerns for specific identifiable persons, or the purchase and sale of land for public use, but not the use and condition of that land, and probable, not possible, but probable litigation or specific legal matters requiring an attorney. And the first exemption isn't meant to conceal discussions impacting groups of employees. And the second exemption is meant to protect the core financial interests of public bodies during sensitive negotiations, as are many of the other exemptions, and it has to be narrowly construed. Also exempt from open meetings law are employee meetings, social functions, and meetings of 2 people, unless those 2 people constitute a quorum or they constitute a committee or subcommittee that's there to advise the public body. All right, so a public body is going into closed session, but they didn't say why. What can I do? With a public records request, you have time to think and respond, but this is not true for closed sessions. A public body can decide to go into closed session before your eyes, and so you need to make a plan with your editor beforehand. And your goal should be to try to stop the closed session, or at minimum force the body to consider the consequences of adopting a casual attitude towards FOIA. And if you believe that a public body is going into a closed session improperly, you should tell the chair, the attorney, or staff member of that body that their motion to go into closed session was improperly made. A proper motion would include an affirmative recorded vote, a citation to the relevant code section that authorizes a closed session, and the stated purpose for the closed session. The motion should also reasonably identify the substance to be discussed in the closed session. And courts decide what reasonable identification means, but a boilerplate reference to FOIA is definitely not enough. And your objection can be oral or it can be written, and you should request that it be recorded in the meeting minutes.
So we got a question, come in about sort of closed sessions and whether a body has to place a time limit on the closed sessions before they enter into one. Off the top of my head, I don't believe that there's any requirement for specific time limit. Like there are sort of procedural requirements that, like Chinmayi was saying, you need to sort of enter into a closed session while in a public session. You need to sort of specify, the subject matter, but sort of the length of time that you could stay closed. I don't believe there's sort of specific language about that. Once you finish the closed session, like they need to sort of re-enter public session and sort of vote if they sort of need to transact public business.
All right, next is an overview of judicial proceedings. The circumstances justifying closure of the courtroom are rare, and the party that is seeking closure must file a written motion in advance of the proceeding, and the public and the press must be given advance notice, and this notice requirement can be satisfied with a posting at the courthouse. The motion must show proof of a compelling need for secrecy and lack of alternatives. And these alternatives would include like a change of venue or a sequestration of the jury. And most often the compelling need that the party is going to talk about will be that press coverage is going to jeopardize the defendant's right to a fair trial, but rarely is there enough evidence that this is actually true. And finally, certain proceedings are routinely closed. These include some juvenile proceedings and evidentiary proceedings about the sexual history of rape victims. There are ways around that though, so if you want to gain access, you should speak with your editor and your lawyer to figure out how. So the judge wants to close a proceeding. What can I do? If you have time, so at least 15 to 30 minutes before closure, you should contact your editor and lawyer so that the lawyer can show up and put a stop to it. But if you don't have that time, then you should stand up on your own and object on the record to the closure and ask for the right to be heard through counsel. And if the judge says no, then you should ask that your objection be preserved in the record. If a hearing is already closed, then you should send a written objection to the judge and ask that the proceedings be stopped and keep a copy of the objection for yourself. There's also no harm in asking, the people who guard the doors if they can just let you in. But if they say no, and like they probably will, definitely don't push your way through. And finally, be courteous and leave when asked, because if you throw a fit, you might get slapped with fines or jail time. And one last point, you should not enter into an agreement with the judge to not publish matters related to the trial, even if your access to the hearing is conditioned on such an agreement, because your speech shouldn't be subject to those kinds of restraints. Last but not least, court records. Court records, like court proceedings, are presumed public, with a few exceptions. And if you're not a member of the Virginia Bar, you're going to have to go directly to the courthouse to access those records. And if you're denied access to records, you should send a written request to the person who is holding those records back. So that would be the judge if he's the guy who sealed the records, or the clerk if that's the person who's responsible. And in your request, you should describe the documents that you want. And if your request is denied, you should also ask that the reasons for denial be put in writing. And finally, some records are sealed by statute. These include jury records, presentence reports, and juvenile court documents. And you're going to have to work with your editor and lawyer to gain access to these records. And just as with public records requests, you don't need to explain why you want certain court records. Finally, what's new in 2022? There are a few amendments that were passed this year that are potentially going to affect your ability to access some information. The first is HB 970. It says that public agencies are no longer allowed to disclose personal donor information without express written permission of donors. HB 150 states that meeting minutes must be posted online or made public within 7 working days of final approval of minutes. That was covered in an earlier slide. 307 says that public bodies shall not charge for the provision of certain scholastic records. So that would affect cost to you, but like in a good way. HB 1303 and SB 5 say that the individual votes of the Virginia Parole Board are not subject to FOIA. So that modifies an earlier rule. And HB 444 says that the local governing bodies, school boards, planning commissions, architectural review, and zoning appeals boards, any board with the authority to suspend occupational licenses, are not allowed to conduct all virtual public meetings, unlike some other bodies. That is it. So now we'll open the floor to any questions that you might have. Ian is going to handle those, and anything about access to proceedings or records, the hotline, or situations that you might face or have already faced are fair game. Thank you.
Thanks so much, Chinmayi. Yeah, I know we covered a lot of ground there. So if anyone it wants to go over anything, wants anything to be clarified, feel free to chime in, and absolutely drop in any questions you may have about, any of this or other issues, you've been experiencing. We did get one question in a few minutes ago, just sort of about like if there's a way that you could sort of gauge the legitimacy of the fee that a public body anticipates, when they're giving you an estimate about the cost of a particular records request. It's unfortunately not super clear. It could be a bit difficult. I mean, you'd have to kind of the statute doesn't specify specific rates that could be charged, so you really have to kind of look at sort of the average cost of doing certain things wherever you're located. The records officer, they can charge for their the time in reviewing, like Chinmayi say, they could charge for like one exclusionary review, but if they're looping in more people to like check things, or looping in lawyers, things like that, like at that point that might not be covered as a sort of recoverable fee by the public body. But yeah, it's a bit of a tricky situation, because could be hard to sort of get a good grasp on what things should charge or should be charged. But like Chinmayi said, I think like for a lot of smaller requests, those that aren't going to be costing hundreds of dollars, a lot of public bodies do sort of waive the fees on those. So that's sort of a good reality, but it's not, you can't guarantee it. So feel free to ask any additional questions. I see another one here. So it's a question about sort of police blotters. If the police may redact, the names and addresses of reported happenings or calls. I think that they're required to provide sort of the statute speaks to sort of the essentially the information that police departments have to provide. Off the top of my head, I believe that they're required to sort of give a general geographic location of an incident. But I think if like there's specific names attached that there might, I don't believe that they're required to provide all of that information, but I would need to check the sort of the specific language of the statute. Let me see another question about records related to domestic issues from the Juvenile and Domestic Relations Court. Are they off limits? So generally in Virginia, sort of domestic or juvenile domestic cases are closed, just generally. So things that like adoption proceedings and the like, they're generally closed, and those records will be sealed. I think it would overall be kind of difficult to get access to those types of materials. But I think there are some situations where you can sort of push back, but it is that sort of a presumptive state of those records being closed.
While we're waiting for more questions to come through, I have a question. When would a reporter be allowed inside a juvenile and domestic relations court? Is it just limited to criminal procedures?
That's a good question. I'm not entirely sure. I haven't had to deal with that issue too much, so I would really need to kind of dig in a little bit before giving an accurate answer one way or the other. My understanding is that for like criminal matters, if it's, a juvenile, defendant, I think that it's more likely that you'll be able to get into the courtroom, whereas sort of, adoption matters, like matters involving infants and sort of those types of sort of personal privacy issues of sort of, infant children, I think you're much less likely to be able to get in. But I think the specific ins and outs, I don't feel, confident in sort of relaying as of right now.
Sure.
Are there resources available from UVA or other organizations in the state to help small news organizations pay for records requests? I don't know. With UVA, we're able to provide our legal, services free of charge, and that includes, the general filing fees for like lawsuits. But I don't believe like we're personally able to fund the underlying requests. I don't know, Dina, is that something you might know of, resources in the state in terms of supporting like the records requests themselves?
I would have to look into that and get back to the person who asked the question. If you want to email me separately, my email address is deanam@vpa.net. Is it synonymous?
Mhm.
Well, I have another question.
Sure.
When a public body is about to go into closed session, and I've seen it done different ways, how detailed do they need to be when they cite those three reasons to go into closed session? Say they're going into session, they cite the code, and then they cite the reason, like purchase land. Do they need to sort of give an idea of about where in their jurisdiction, like in the such and such community, how detailed do they need to be without giving away everything?
Yeah, so I think, generally they're not able to just cite, the code generally, like you said, like they need to cite sort of the specific provision that allows them to go into session. Then they need to cite, the subject matter that they'll be discussed. So they do need to provide, some information regarding sort of what they will be discussing in closed session. But, it's sort of one of those things where I think it's a bit difficult to, to say one way or the other. I think it's always, good to push for, more clarity, more description if possible. And like they do have a requirement to really let why they're going to closed session, what they're discussing, and what the justification for going into closed session is.
Okay. Looks like we have another question.
Oh, sure. I've gathered information from a court record regarding a lawsuit, and then later as a settlement agreement between the parties, records are closed. Can I still use the information I gathered earlier? So I think it's, even when the parties, stipulate that something be closed, and, like there's always like sort of a public interest, like sometimes, courts might, rubber stamp, when the, plaintiff and defendant, want records to be sealed, but like that's not really, how that process is supposed to occur. The press and public have an access right and interest. So I think, and in this scenario, it sounds like the press already had the record, from before the settlement agreement was reached. I think that it would be, I can't right now. I can't think of a reason why sort of that the private agreement between the parties would sort of supersede the press's ability to use that record. But again, with like questions like this, it's kind of fact specific. It kind of deals with exactly the nature of the settlement agreement and the records. So it's it really can't give like a clear answer one way or the other. But I will say that there is sort of press and public interests in accessing court records that sort of go beyond sort of the parties themselves and their preferences.
All right, well, we can wait for a few more minutes or another minute and see if we have any more questions from the audience.
Sure.
Ian, are there any particular FOIA related questions that you see, more frequently than others?
Yeah, I mean, I think in terms of like FOIA, records issues, we see a lot of questions regarding prison records, and we've worked with a fair number of journalists who are sort of seeking, records produced by prisons. Not, in the past, some reporters we've worked with have been sort of seeking health-related records. Others are seeking information just about use of force within prisons and things like that. And the exemptions around those issues are quite broad, and they sort of provide the prison administration with a significant amount of discretion in terms of what records are released. So we've seen sort of those issues crop up quite frequently. I will say that we have had a bit of luck sort of in opening up sort of lines of communication with the prison administrations, and sort of in effect like negotiating some information to be released on a discretionary basis. So that's something that's always possible with these public records requests. Like even when the agency, the public body is provided with discretion over what to release or not, you can try and persuade them. So we've had some success there, but not all the time. Sometimes they will sort of dig their heels in and refuse to release anything of use. But I think like sort of the issues surrounding that discretion are pretty frequent in terms of the public records issues we've seen. Other than that, we've seen some issues regarding other statutory provisions, like other statutes. Virginia statutes can sort of interact with Virginia FOIA. So even if a specific exemption is not stated in the statute, other laws might prohibit the release of certain information. So we've seen some examples where public bodies have seem to be pointing to that to justify a mandatory withholding without kind of clearly saying why they're doing so. So that's always a bit frustrating. And then on the public meeting side, we've been seeing some issues regarding meeting cancellation or rescheduling, and sort of the notice requirements and things like that. So I think those have been sort of the more common issues we've encountered.
Thank you. Well, it looks like we have no more questions today, but so I guess we'll end it here. I want to thank you, Ian and Chinmayi, for such a great session today. The hour's flown by, and I think we're all better informed because of the information you shared with us. Thanks to all of our participants. We're glad you joined us today. And we will send out a link to the video and the slides in the next few days. We hope you have a great rest of the week.
Yeah.
Thank you.
Thanks, everyone. And, like I said before, we're happy to field any questions about, specific issues you're encountering through the hotline, or, even if you are, want a little bit more clarity onto any of the general overview topics we've covered, feel free to reach out to me over at the clinic. So I'm happy to chat about any of this.
Thank you. Bye.